Good morning. Well, something happened in the Indian Parliament which has made history, and it is the suspension of 141 member of parliaments. 141 MPs got suspended because they came into the well of the house in both Rajya Sabha and Lok Sabha, and they were protesting with placards. This kind of protest is against the rules of the conduct of the house. With the suspension of these 141 MPs, a history has been created because never has this happened that such a big number of member of parliaments have been suspended. It has once happened before in 1989 when the same sort of protest happened because of the Bofors scandal. But during that time, 63 member of parliaments were suspended, and they were suspended for 3 days. Here 141 member of parliaments are suspended. This suspension has took place over 3 days. On 14th of December, 14 member of parliaments got suspended. On 18th of December, 78 member of parliament from both the houses got suspended, and then on 19th of December, some 49 member of parliaments got suspended. This has made history. 78 member of parliament getting suspended in a day, that too for the whole of the winter session. Some are calling this as the tyranny of the government. Some are calling it as undemocratic process, because technically the opposition has been thrown out of the parliament, and whether this step taken by the Speaker of the Lok Sabha and the Chairman of the Rajya Sabha is constitutional or not, whether, of course it is in their power, but for the whole democratic process, this is good or not, has been a debate going on throughout the country. Now let us see how this thing has started. On 13th of December 2023, this happened to be the 22nd anniversary of the 2001 Parliament attack. 13 security personnel gave their life to save the parliament in this day, 13th of December in the year 2001. On the anniversary, on the 2023, means a few days back, on the 13th of December, two young person jumped into Lok Sabha from the gallery. They were carrying gas cans. It has some yellowish gas which is termed as a gas bomb. Now this gas bomb, and how they are able to take these sort of bomb in the plastic bottles which were kept inside their shoes, they have entered the Lok Sabha. It's a major security breach. It's a major security breach. What opposition did, opposition started to ask for the statements of Home Minister and Prime Minister. Basically, the security of the parliament is looked after by the Home Ministry. So it made sense to ask for the statement of Home Minister. Along with it, The two persons who have entered the premises and the gallery of the Lok Sabha, they were allowed on the pass issued by two BJP MLAs, MPs, sorry, two BJP MPs. BJP, as we all know, is the ruling party in center, and the Home Minister is of the same party. So opposition started to ask for a statement. Then the opposition went on to ask for a statement from the Prime Minister also. This protest started to grow more and more as the Prime Minister and Home Minister were not coming for any sort of statement. Prime Minister to one of the daily Hindi Samachar Patrika told that it is a serious thing which has happened, the security breach is a serious thing, but there is no need to politicize the matter and start a debate in the parliament for such a small thing, which of course is not a small thing. Opposition became more and more aggressive, and it went on to the level when they have started to enter the well of the house in both Lok Sabha and Rajya Sabha, breaching the rules of the conduct of the house. And then the Lok Sabha speaker under rule 374 and Rajya Sabha speaker chairman under the rule 256 suspended these MPs. For suspension of MPs, a motion is passed by a minister, Parliamentary Affair Minister, or any minister. The leader of the house passes the motion, which is then accepted by a voice vote. After the acceptance of this motion with the voice vote, and if this voice votes gives the green signal, means the majority of it accepts it, then this motion is passed. And once this motion is passed, the member of parliament against whom this motion is moved stands suspended. So this is how the process have taken place of suspension of MPs over 3 days in parliament. Now from all this debate, we are going to come on several important topics which is important for our examination, UPSC examination. We will look into Article 75(3) of the Constitution of India, which talks about the collective responsibility. Second thing would be to look into the impact of suspension, how this is going to impact the Indian parliamentary democracy. Third thing is if there is some remedy available to the member of parliaments who got suspended. Then we will look into the alternative. If an alternative path could have been taken instead of suspension, what could that have been? What would that have been? Fifth, we are going to see how disruption in the parliament can be minimized. How to minimize the disruption in the parliament. And last but not the least, I can write here, we are going to see what is privilege committee. and what are its work. Now, all these issues are important for our examination from the point of view of our examination, and they are all related to the suspension of the 144 member of parliaments. So, let us first look into article 75(3). It talks of the collective responsibility. What is this collective responsibility? We know that there is something called presidential form of government and there is something called parliamentary form of government. India follows the parliamentary form of government, not the presidential form of government. The basic difference between these two governments is that the presidential form of government works on the principle of separation of power, whereas parliamentary form of government works on the principle of cooperation and coordination. Cooperation and coordination, which simply means that the Council of Minister is responsible collectively, and all the MPs individually and collectively are responsible to the Lok Sabha, means the House of the People. They sail and sink together, as it is called, in the parliamentary form democracy. Now, it becomes very important for the Council of Minister and the associated ministers, the cabinet ministers and the home ministers and finance minister and prime minister, to answer the queries, doubts of the member of parliaments, because there is a sort of responsibility they have towards the parliament, and it is the job of the parliamentarians to ask question. What happened after the breach of security in Lok Sabha and Raj Sabha was that the parliamentarians were doing nothing but their job of asking question, asking statement that how can such a thing happen in the new building of the parliament. But it is important to see the way in which they were protesting. The way was wrong, of course, bringing placards into the well, climbing onto the chair of the chairman of the Rajya Sabha. This is not the kind of protest which is appreciated in the parliamentary democracy such as India. So, article 75(3), which talks about the collective responsibility, also talks about the duty of the parliament, duty of the government to give answers to all the queries and the demands and the questions of the opposition and also of the other members of the parliament, including their own party members. Now, let us come to another important issue, which is the impact of this suspension. What is the impact of this suspension? If we look, the parties have formed India Alliance. This India Alliance is a major alliance against the ruling BJP party. This India Alliance have several parties and their member of parliaments inside that. Out of the 543 member of the Lok Sabha, 142 members are from the India Alliance. This is the position in Lok Sabha. Out of the 250 members of the Rajya Sabha, some of the seats are vacant, but out of the 250 members of the Rajya Sabha, 101 members are from this India Alliance. Now we see almost 95 members out of this 142 members got suspended, and in the Lok Sabha, and around 46 members out of this 101 got suspended in Rajya Sabha. This is around 70% of the opposition in Lok Sabha, and this is about 50% of the opposition in Rajya Sabha, which is out of the parliament as of now. Now, with such a less member of parliament who represents the opposition sitting in the house, it is very easy for the government to pass any bill in whichever way they want. Several important bills such as telecommunication bill, bill to replace the Indian Penal Code, Criminal Procedure Code and the Indian Evidence Act, they are all tabled in the parliament, which have now been passed without any discussion. The work of the opposition is to form to find faults in any bill, then it goes to committees for improvement. After it has passed from the committee, after it has been improved, then the bill becomes the act in the parliament. So, it is very important in a parliamentary democracy to have a good healthy opposition and a healthy debate, which has been hampered because of this suspension. Important bills are being passed without discussion. This is a serious issue. The replacement of IPC, CRPC and Indian Evidence Act, the whole judicial process depends on these three acts. Now, how government can pass act without technically without opposition? See, to pass any act, this is again important from the examination point of view. Now, this part is over and this part is also over. To pass any bill in the parliament and to make it an act, 10% of quorum is required. That means the attendance of 10% of the total strength of the house, whether in Lok Sabha or in Rajya Sabha, is required. That simply means out of 543 Lok Sabha members, if 54 or 55 are sitting, that completes the 10% quota, and then the parliament can move forward with any bill. The ruling party, the ruling BJP party, has a brute majority in the parliament. When it has the brute majority, it not only fulfills 10% quorum, but it also fulfills the 2/3 majority clause, which is there for several bills. For most of the bills which are going to be passed in the parliament, 10% quorum is the requirement. The second kind of requirement is when the 2/3 majority, means 2/3 of the members sitting and voting are required in the parliament. That happens only when there is removal process, impeachment of the president, vice president, judges of the Supreme Court, High Court, the members of the UPSC, all the constitutional bodies. The removal is there. Then for that removal to happen, 2/3 majority is required. After that, Article 368, which is about the amendment in the constitution. If you have to make amendment in the constitution, 2/3 of the majority would be required. Then to make any law, parliament, if parliament has to make any law on the state list, then again 2/3 majority sitting and voting, that will be required. Present and voting will be required. And after that, if the Rajya Sabha has to make all India service, again 2/3 majority would be required. But for all the other bills to be passed, 10% of quorum is enough. So, these bills, although they were very important, but were not among these, and hence 10% of quorum would be enough to pass such bills. So, important bills such as telecommunication bill, the replacement of the IPC, CRPC bills, all of them, Nyaya Samhita bill and other bills, Saksh Samhita bill, all have been passed technically without the opposition, without any finding out any kind of faults in them, because more than half of the opposition is out of the parliament. This is one thing. Now let us come to we can also see the quorum. There is a difference between the quorum as has been practiced in the United Kingdom and India. In India, it is the duty of the presiding officer, whoever is there on the chair, whether the speaker, the deputy speaker, or chairman of the other dignitary who is sitting on the chair, the presiding officer. It is the duty of that officer to see whether the house is fulfilling the 10% quorum which is required to run the business of the house or not. If it is not fulfilling that requirement, then the house needs to be adjourned. Whereas in the United Kingdom, what happens is the 10% quorum requirement is not noticed by the presiding officer till the time a minister or a member raises this issue. There is a opposition from any member or the minister in the UK Parliament that the quorum has not, the requirement for the quorum is not fulfilled, hence the house should not do its regular business. If there is a opposition from any member of parliament, then only the requirement of quorum comes into picture, or else it is the duty of the speaker to run the house. What happens is the day-to-day business in the United Kingdom Parliament goes on without the consideration of quorum. Majority of the time it happens like this. Then let us come to the another issue which we are going to see is what are the remedies available? What are the remedies available to these suspended member of parliament? What are the remedies available? The first thing, if we see, they can go to court. Can they go to court? There is something called the internal autonomy of the house. That simply means the decision taken inside the house cannot be discussed outside. There is no judicial review on the decisions taken by the house together, especially by the speaker and the chairman of both the houses. So technically and legally, the member of parliament who got suspended cannot go to the court. This is not the remedy which they can avail to. Only if a plea is filed in the court that the whole rules of conduct is unconstitutional, then only the whole rules are unconstitutional, then only the court can take up the suspension issue of the parliament. But before that, no remedy of the going into the court can be availed. The second thing, if these member of parliaments can be called back, yes, they can be called back. But how? Again, the majority of the members sitting inside the house has to agree with it. Now the same majority has suspended them. Why would the same majority help them to come back? So technically, if we see, going to court is not the remedy they can avail, and calling them back by passing a motion with majority does not look to be the possibility. So no remedy for these suspended member of parliaments is at place as of now. Now let us come to the another important issue, which is what alternative can be available instead of suspension. Can there be something else which could have been done? It have been done earlier also, that if there is heavy disruption in the house, usually the house is adjourned for the day, and with the help of the speaker of the Lok Sabha and the chairman of the Rajya Sabha, this issue is amicably solved. This issue can be amicably solved outside the parliament. Both the parties or whatever number of parties which are there, the whole opposition and the ruling party, their members, their leaders can sit together in the presence of the speaker and the chairman and resolve the issue amicably instead of suspension of these member of parliaments. So this is one of the alternative which was not even looked into, and on the breach of the rules of conduct of the houses, MPs were suspended. Now coming to another issue, how to minimize this sort of disruption in the parliament. This is important issue. Now there have been several committees. One of them was chaired by the Honorable Venkaiah Naidu, who was the presiding officer and the chairman of the Rajya Sabha before. He said that any kind of ruckus, if seen in the parliament, then automatic suspension is one remedy. The report of this committee said that automatic suspension of the member of parliament, if he or she is creating any kind of ruckus in the house, should be followed. Another thing, Vidhi, it's a think tank based in Delhi. It came up with an idea of Parliamentary Disruptiveness Index, Parliamentary Disruption Index. This will bring up an index, and this will be based on the naming and shaming. They will name the member of parliament who is at the top, of disruption of the parliament, and the name of that parliamentarian would be made public, that because of this parliamentarian the parliament has been disrupted the most. There can be several. So this parliamentary disruption index, this is one of the things used in the United Kingdom Parliament. Another important thing which is there in the parliaments of United Kingdom and the United States is one day of the week. This is important. One day of the week, the discussion is opposition led. There is going to be opposition led discussion. Opposition can bring up its issues and starts the discussion in the parliament on that given day. For example, if the parliament is going to run from Monday to Saturday, any one day, let's say Monday, can be the day for the opposition to lead the discussion. They can bring up any issues. Now, we do have our own versions of this opposition led discussion, which is the 0 hour and the question hour. But the 0 hour and question hour, it is seen that usually the Prime Minister of India is absent during these two important discussions. And when the Prime Minister, nobody can replace the Prime Minister. But what happens in the United Kingdom, during this opposition led discussion, opposition asks questions from the Prime Minister, and it is the duty of the Prime Minister to satisfy the questions of the member of parliaments. So if such a practice is going to start in India, it will be very important that it is going to minimize the disruption in the parliament. Another thing was to form the code of conduct. Code of conduct for the member of parliament, the council of ministers, the members of the legislative assembly. This code of conduct is going to define that what is going to be their proper conduct within the house, outside the house, especially when they are protesting, in the well of the house, what is going to be their conduct. If these things are codified by law, if it is made statute, if statute provisions are brought in, then it is a possibility of minimum disruption of the parliament. Now let us go to another issue, which is the privilege committee. Now let us come to the privilege committee. What is this privilege committee? It is very important topic. Article 105 clause 3 of the Constitution of India gives power of the parliament to make law. By law, it can go on to decides its own powers, privileges and immunities. These powers, privileges and immunities, which are defined by the Parliament for itself, are very important for the independent functioning of the Parliament. Independent functioning of the Parliament. Now, there are several privileges. There have been customs, several rules which are made, several old parliamentary habits which are followed, which combinedly make this privilege. And if there is any breach of these privileges, the parliament or the speaker of the Lok Sabha and the chairman of the Raj Sabha is entitled, his or her right to send a request to the privilege committee, and this privilege committee looks into the breach. This privilege committee looks into the breach of the privileges of the parliament. Now, this privilege committee in Lok Sabha consists of 15 members who are appointed by the speaker of the Lok Sabha, and in Raj Sabha this committee consists of 10 members which are appointed by the chairman of the Raj Sabha. What happens is, once a report is sent to this privilege committee, it acts as a court in itself. It is an adjudicatory body which acts as a court. It can ask for testaments, it can ask for oral or material testaments to prove whether some breach has happened or not. So, it is a specialized body which look into the breach of the privileges of the parliament, and if it is proved, it sends back its report to the authority, either to the house or to the chairman or the speaker of the Lok Sabha. It sends back the report, and if the report says that the breach has taken place, or it can also say the breach has not been taken place based on the findings of this committee, now it is upon the house to either accept fully or partially or reject the findings of this committee. So, privilege committee is one of the most important committee in the parliamentary culture to save the parliament and its independence. Now, important thing for us here is this article 105(3), which defines the powers, privileges and immunities to the member of parliaments, always stands, some or the other issues always comes up with the fundamental right followed, which is given to the citizens of this country by the constitution. How it happens? Let us understand by one case. What happened in the Uttar Pradesh Legislative Assembly, one editor of a newspaper started to make went on to write in its newspaper the speech of one of the member of the Legislative Assembly, whose half of the speech has been expunged. Means that part of the speech has not been recorded, that has been expunged by the Speaker of the Legislative Assembly. But this editor of the newspaper went on to not only print the recorded part, but also the expunged part. Now, when this report or the editorial which has been printed in the newspaper, it has been considered as the breach of the privilege of the Legislative Assembly, and the whole issue was handed over to the Privilege Committee. Privilege Committee gave its report saying that privilege has been breached, and the Assembly has passed a motion to stop the editor from printing such material. The editor went to the Supreme Court filing a petition under Article 32 that his fundamental right to expression, which comes under Article 19(1)(a), has been breached. He has been stopped from expressing himself in the newspaper. The court gave the judgment in favor of the Legislative Assembly of Uttar Pradesh, saying that fundamental right, especially the right of expression under Article 19(1)(a) is a general article, whereas Article 105 is a specialized article, and it is important for the Assembly to maintain its independence, and whatever issue is there inside the Assembly and whatever decision the Assembly makes by passing a motion, if any of the fundamental right is breached, the decision of the Assembly would be upholded. So, it is very important to understand that the Parliament and the legislative assemblies and the decision they are taking through passing a motion becomes more powerful than the fundamental rights. There is another case where in a legislative assembly, when a person disrespected the speaker and the members in that legislative assembly, a motion was passed to issue an arrest warrant for the person. This person was arrested and he was kept in a hotel room for 6 days. Meanwhile, his lawyer filed a petition in the Supreme Court, again under Article 32. You can approach Supreme Court if your fundamental right has been breached. So, Article 32, the petition which was filed was that his fundamental right, and this was the habeas corpus writ petition. It was a habeas corpus writ petition which said that his fundamental right given to him under Article 22(2), which says that anybody who has been arrested should be produced in front of a magistrate within 24 hours, has been breached. The Supreme Court has given order in favor of this person, that a person cannot be detained in a hotel room for 6 days without being produced in front of the magistrate. So, usually court has given orders where a court somehow wants to create a balance between 105 article and the fundamental right, but of course the court leans heavily towards Article 105(3) towards the independence, so that the power, privilege and immunity of the Parliament is not hampered and the Parliament can function independently. So, this is it from our lecture today, and I hope you enjoyed it. I hope you understand few important principles and few important concepts which is needed for our UPSC preparation. Thank you.